Good morning, everybody. I'm Joe Storch. I'm an attorney at the State University of New York. This is my colleague, Seth Gilbertson, who's also an attorney at SUNY. And we are here.
This is our brother, Daryl.
Our other brother, Daryl. We're here to talk to you about e-discovery. Now, before you run from the room in the other direction, we are going to try to make e-discovery and records management something that is accessible, something that is useful, and something that you'll be able to take back to your campuses around the country and really start to implement something that is, believe me, long-term in your interest. So what are we going to talk about today? We're going to talk about e-discovery in our first part one. We're going to really harp on e-discovery and the different aspects of e-discovery. We're going to talk about the different steps in the process of the lawsuit and e-discovery and records management. We're going to give you sort of from the beginning all the way to the end. We're going to give you a short intro on records management. The part two is really more intensive on records management and things you could do to make your life much easier in the long term. And we're going to talk about some of the features of a strong records management program. And in part two, we're going to go more deeply into records management and talk about working with third parties and vendors and email and e-discovery and the like. So what is e-discovery? Seth and I define it a little bit differently. For Seth, it's a shorthand term for the process of preserving and exchanging electronically stored information in the context of modern litigation, and that is a really accurate definition. For me, it's discovery with an E in front of it. And I say that tongue-in-cheek, but I think we're both right, and I think you'll understand why. Seth's definition is very precise. And what my definition is really trying to foreshadow for you is that there's nothing new under the sun. E-discovery is discovery that occurs in a digital domain. And we can't reinvent the wheel. We take traditional concepts of discovery and apply them in the digital world. So you're asking yourself, why should I care about this? I'm not in IT. Perhaps you are not an attorney. Maybe you're in student affairs, or you're in contracts, or you're in another group. Why should you care? And the answer is that there are a lot of types of e-discovery. There's the traditional e-discovery that you'll hear about during our presentations in the litigation context, federal and state litigation. But we also have, if you're a public institution, freedom of information, or maybe your state calls it a sunshine law, or whatever they call it, requests by students, by guests, by agitators, whatever it may be for information. And we also have audits and program reviews. You've heard a lot at this conference about program reviews from the Department of Education, from OCR, from other Department of Labor, perhaps. And what you need to hold for those audits is also e-discovery. And we're going to talk about that. So when we talk about these federal lawsuits, we're talking about a lot of different things. We're talking about claims. We're talking about denials of tenure and other aspects of the labor market. We're talking about, if you're a public institution, constitutional, First Amendment. You might have a speaker who wants to come onto your campus, and they're denied access to come onto your campus, or maybe a student or somebody assaults them while they're on your campus because of what they're saying. You have contract violations. You have real estate deals gone bad, torts and cases of discrimination and the like. And in freedom of information and sunshine requests and audits and program reviews in state and federal lawsuits, one of the things that you're going to find that goes through all of this is that they're document intensive. Back in the day, a while ago, 10 years ago, 20 years ago, when someone would come to your campus, you would go to the appropriate drawer of your file cabinet, you would open that drawer, and you would take out the big manila folder, and you would have someone rexograph it or whatever it may be, and then you would supply it. But everything was held, not all centrally, but more centrally. Now, you have documents that are held by your registrar, and some that are held by student affairs or judicial, and some that are held by faculty members. Maybe some of your student workers who've graduated have some of these documents. Maybe you've deleted them. Maybe someone forwarded it to their Gmail account or Hotmail, or they printed it out and then they're dog-gated, or who knows where these documents are. So you have to ask a lot of questions when you get an audit or a FOIA request or a lawsuit. Who has what? Where do they have it? How are they storing it? And then you may ask the more intensive question, why the heck did we allow this person to have these documents in the first place? And all of these require production, so all of these require adherence to strong records management policies, and that's what we're going to get into and try to give you some sense of. And also we're going to tell you places where you can find out more information and get some samples to build things for yourself. In a lot of ways, SUNY has done a lot of the hard work on this, and we put it all out on the web where it's accessible and can be grabbed by other colleges, public and private, across the country, and use it. And we like to say,
we stole most of it from you anyway. So.
Right, right. It's the circle of stealing. We like to say that, just as Grandma used to say, the stitch in time saves 9, a few minutes organizing your files and organizing your colleagues on what you're holding can save you hundreds and thousands of hours and millions of dollars down the line. So that's what we want to do. So what do we want to do today? We're going to try to translate these requirements into English, demystify and explain them. We're not here to scare you. We don't have some answer or a product. You're going to hear in e-discovery, you're going to hear a lot of people who will email you, who will write to you, and different people on your campus saying, e-discovery is going to kill you, but you can buy our product for millions of dollars and we can save you that. We're not here to do that today. What we hope to do is translate this sufficiently into English so that you'll be able to take it home and say, I get what I have to do, and let's go do it. So Seth, why don't you talk a little bit about e-discovery and introduce.
Okay. First, I just want to say, Joe's right, we're not just trying to sell you on what SUNY does, and we're not here to talk too much about ourselves. So we apologize for all the propaganda up there, but our branding people will literally come and drag us out of here if we don't use it. If it was up to me, this would all be black and white Times New Roman. If it was up to Joe, it'd probably be in 3D with like lasers shooting out of it and such. So not our call there. But the other thing about Joe that I forgot to mention here. So I always tell people that I'm sort of the Al Michaels of this presentation. I do the play-by-play, and he's more like the Joe Madden without the big hands and does the sort of the color aspect of it. He took it literally last night, and can I just show you what he did? He went through and added color to all of his slides, and none of mine. So would have taken him 10 seconds just to include mine in. So what are we talking about when we're talking about e-discovery, generally? Joe gave a good introduction there, but getting down to more nuts and bolts stuff of it, we're talking about rules that are created primarily by the federal courts. As Joe said, they apply in many different contexts, in many different arenas, and many things that actually in higher ed we deal with more than we deal with federal litigation, hopefully. At least we aim to deal with more than we aim to deal with federal litigation. But the rules really come from the federal courts. They've got the time, the resources, the stakes are really, really huge there, so they're the ones that have sort of put a lot of the rules in place and put them out there, and then they've been adopted by state courts, they've been adopted by administrative agency, they've been adopted by even internal audit control procedures and those types of things. So the real sort of benchmark for those is a case, and you'll hear about this, and many of the lawyers in the room have heard about this and know about it and have read it, called the Zublake or Zublaki. It can be said, for such a landmark case, nobody really knows how to pronounce it, and I don't. I've heard it said both ways. It's really a set of 3 cases, but that really laid down the rules for the sort of like I say, the groundwork that has been added to over the years, over the last 12, 15 years, through federal courts decisions and through organizations such as the Sonoma Conference, which has really kind of become an arm of the federal courts in some ways. So, we're often used to describe the pre-discovery, and this actually goes all the way back to Zublaki, the equally important part of implementing a litigation hold. And why is that equally important? It doesn't sound equally important because you're not even being sued yet most of the time. But it really is, because that's what allows you, that's what gives you both the leverage and the ability to be able to go into court if you have to and make your case and know that you're not going to lose, you're not going to have sanctions levied against you because you didn't do that. It really has taken litigation and taken it back a step, and that's why we talk, that's one of the reasons we talk. Really, I would say it took it back 2 steps. It took, and we'll go through the steps here in a second, but it took it back to the step of implementing a litigation hold, and that took us back to the step of having to have good records management policies, which of course at the same time is becoming much more difficult because of the technologies that are available to all of the thousands and thousands of end users across your campuses. But we'll talk a little bit. I'm going to keep saying we're going to talk more about it later because we do have like 3 hours up here. So we're trying to cover everything. A lot in the first section, but we'll go into a lot more detail in the second section and get into some of the bells and whistles, and that's where we'll have the cartoons and stuff like that as well, so stay tuned. One of the biggest changes that sort of this evolution of discovery and the e-discovery has made is that it requires a lot of collaboration between IT departments and legal departments. Many of the lawyers in here know, 10 years ago you probably didn't know your IT person. Now you have to. You have to have a basic understanding of your IT framework, or at least somebody in the general counsel's office will have to, and have that repertoire and be able to work together, because there's so much crossing over now. What we need from them, what they need to know from us, so that they can do their jobs appropriately and protect the institution just like we're trying to do. And then that trickles down in a way to where many of you probably fit. And I know we have a whole smattering of people from all over campus in this room and at this conference, but you're all end users ultimately. That's how the IT people view you, and we're, as lawyers, we're beginning to view you even more that way. You're not just litigants, you're not just witnesses, you're also end users. And we really need your cooperation. Of course, all of you are going to be very cooperative and friendly and play well with your lawyers and your IT folks, but we're going to also talk about some of the bad people out there that work maybe for you that don't do that, and how we deal with that. So again, it's constantly evolving. It's old concepts being applied to new technologies, which is way more difficult than it sounds. In many facets of life, that just sort of happens and people get used to it. But in this area, it's really caused a sea change in what discovery is. As Joe said, though, the concepts are the same, the legal principles are the same. It's just how they're applied to this new world that we live in that's really changed a lot. In so doing, it's caused a huge increase in the quantity, not the quality, the quantity of potential evidence. The quality of potential evidence has gone way down. It is nosedived. Okay, it used to be you only saved things because there were space limitations, etc. You only saved things when you needed them and when they were worthy of being saved. Also, you only created something. You wouldn't put something in a typewriter and go to all the trouble of typing it unless it was at least there was some threshold of importance that you had to meet before you did that. Now there's no threshold anymore, and everybody can do it. You don't even need the type. All you need is a computer, and all the end users have them. And they all also have, to go along with it, unlimited storage capacity. So that's going to be one of the themes we're going to go along with. The quantity of potential evidence has gone way up here, and the quality has gone way down. It's really, the quality has about stayed the same. It's just that the quantity has gone up, so percentage-wise, it's much smaller. We're looking for a needle in a haystack now, and used to be we were just looking for a bale of hay in a haystack. So it's led to that has led to a huge increase in the cost. We're going to talk about that more this afternoon, but one of the things that we really have to think about, and one of the things that sort of the e-discovery community, I would say, is thinking a lot about is who pays and is it fair. Generally, I'll tell you at this point, you pay. Your institution pays. Again, there are questions about whether that's fair, but generally the answer is going to be you pay. And so that's one of the sort of lessons learned, is because that can be used tactically by plaintiffs' attorneys and by plaintiffs and by even auditors to come in and just know that they can drag you through all kinds of trouble even if you did nothing, because you're the one, they get to bring the claim and you're the one that has to respond, and responding can get very costly if you're not properly managing your records on the front end of it in order to control those costs. All right. We're going to sort of intersperse this little storyline through it to illustrate some of the points we're trying to make and sort of make them real to you if that's possible. So we've got this little hypo that we're going to start here called the relevant quiz. So OCR, Office of Civil Rights, many of you have dealt with the Office of Civil Rights before. It's an arm of the Department of Education that primarily investigates discrimination of all forms across campuses. So they touch on many different areas of campus, and many of us have dealt with them. But They notify the institution that a student has filed a complaint alleging that she was denied a reasonable accommodation. So she has disability and she's supposed to get an accommodation. We're all familiar with that, or many of us are, at least on a basic level, right? We're not going to get too much into it. But she has an anxiety disorder. And she's supposed to be allowed to take exams in a distraction-free environment. This professor gave her a quiz in class, and she just took it and then probably didn't get a grade that she doesn't like. And we see this kind of thing happen from time to time. And now she's filed a complaint with OCR. OCR comes to us and says, we've got usually the first thing they do is they come out, and this is another good example of how your costs can get out of control in this area if you're not managing your records. They notify the institution, and they send you, there's a complaint, and they send you a document demand, a request for records. And that's what they're asking for here. And sometimes they are just this broad. Give us everything. Sometimes they'll say, we want this email from this day and this policy and that kind of thing. A lot of the time, they'll just say, give us everything relevant to this. And then you have to call and barter with them back and forth about what that really means. But the bottom line is they've come in and they're requesting all these relevant materials. And we haven't talked about what those materials are yet, but we'll get to that in a little bit. My question to you is, do you recognize now, after the things we've talked about, that the answer to this is probably yes? This creates an e-discovery problem for your campus, an e-discovery event. And that happens all the time, right? At every one of our institutions. So just trying to bring it home again for you here a little bit. I guess this one's mine too. So what are the steps we're going to talk about? We said we give you the e-discovery steps. We go through this. The first one is sort of the last one we talk about. We sort of put them invertedly because I think you have to understand sort of the e-discovery process to really understand why records management is important and why you'll actually listen to me, because it's boring. So the first step really in the actual e-discovery process, which is number 2 up here, is to determine litigation hold triggers. Joe's going to talk to you about what a trigger is in a minute. But that's a very important part. It requires you to work with counsel quite a bit. Joe, like I said, is going to talk about it. Then you preserve. That is actually the litigation hold, preserving the relevant records. You got to review them at some point. Maybe not. Maybe you just put them aside and you never end up getting to them because it never comes to fruition, whatever kind of claim you were worried about. But a lot of the time you end up in a situation where you're having to review and sort through all this massive universe of data. Eventually, you may have to produce them. We're already to this level in that one simple little OCR example. We're already having to produce them. So we've already gone through all that, or we will end up having to go through all that. We already know that going into it. Clawback, that's just a term that means sometimes you give too much and you want some back. But we won't talk a lot about that. It's not really relevant except for to the non-lawyers out here. And then finally, this one is very relevant. You have to be able to explain what it is that you're producing, what it is that you've saved, what it is that you've identified as potentially relevant information. And a lot of times we get bogged down in the process of e-discovery and trying to find the records and make sure we have all the records and make sure we know where the records are and to see if they have privileged information, all that kind of stuff. And we forget that we're in the middle of some kind of probably adversarial situation where we better be able to explain what it is that we're producing and marshal it in our own interests and not just the interests of whoever's bringing it. So without further ado, here's Joe talk to you about triggers.
So how do you know that you have an event that is going to involve potentially an e-discovery question? Not every event that occurs on your campus. There are a myriad of events that occur every single day, and the vast, vast majority of them will never result in anyone sitting in front of a court or answering to an audit or a freedom of information request. So one of the key things that you want to do early on is discuss with the members of your staff and with your colleagues across campus. And I think one of the themes that you're going to hopefully take away from this series of presentations is that the silos are not going to work. Our office just deals with our office and your office just deals with your office because so many of these e-discovery questions run the gamut across the campus. So as you talk to your colleagues and to leadership and to those who work with you, how do you know that this is something that we should care about? So many things occur on the campus every day. You can't possibly treat each one as an e-discovery event. You have to look to those that reasonably anticipate litigation. And you don't want to do that on the fly. It's easy. Sometimes there are really, really easy examples. Those are usually tragic things that occur on your campus where you can say, easy answer. We can anticipate litigation for this. And sometimes they're really small things. The student who says to the professor, if you don't give me an A, I'm going to sue, and they were doing charitably D+ level work. Who cares? That's not going to turn into something. But there are a lot of things in the middle. So one of the keys is figuring that out. So what's the likelihood of litigation in any event? Well, a couple of factors that come into it. Where did it happen? How much control did we have over the incident? If it's something that occurs far off campus, a student says, well, I was traveling overseas and I got into a car accident. That's a lot different from I was just run over by one of your snowplows that your campus operates. That significant differences in location and control and the like. There's a cost-benefit question. Some of the questions are going to be massive, and you understand that you should incur significant costs because you understand that this is going to be a massive lawsuit. When the tragic incidents occurred at Virginia Tech, they knew right away that they were going to be having some type of investigation of litigation. That's a massive thing, and it's spend what we need to spend to preserve the documents appropriately. There are other events. You may get a call from a software vendor who said, we had a $180 contract, and you haven't fulfilled the contract, and we're going to sue. And you might say, even if we lose and have to pay out the whole thing, is it worth spending $3,000 to preserve records to protect us in a $180 lawsuit? So cost-benefit, fortunately or unfortunately, really does have to be a part of this. So a couple of different examples. The president denies tenure after some mixed reviews. That is almost always, or at least in our public system, that is almost always a qualifying, triggering event. You will almost always hear something down the line of a tenure denial when there are mixed reviews.
If faculty are involved at all, generally it's a trigger.
Right.
Sorry for the PhDs in the room, but it's...
A visitor at a baseball game calls with a complaint about the hot dog and says, you'll be hearing from my lawyer. Well, let's look at the questions that we asked before. Yeah, the location. Yeah, we have control, but what evidence do we have? Do we have are we going to go take, swabs of the remains of all the hot dog carts? And they just said, he had food poisoning. What's the harm? The cost benefit, you're probably not going to do much preservation here. A software vendor complains that you haven't fulfilled the cost of your contract. Okay, well, is it Banner complaining, or is it PeopleSoft, or is it some little .com with a $200, $300 contract? If it's Banner and you've broken off your contract with Banner early and terminated in violation of the contract, I'd hang on to some paper. If it's one of those $180 things, I wouldn't bring the cavalry out.
Of course, it's not paper, it's in Banner.
Right. Well, right. It's all stored in Banner. A couple other examples. The Department of Education writes to your president initiating a program review for Clery Act compliance. Is that a triggering event? You betcha. OCR notifies you that a complaint has been filed, but they're seriously backlogged and we won't be able to get to it for 6 months. That's a trap. That is absolutely a qualifying event, and you'll have the added necessity of making sure that you hold it for a long time. We have had colleges that have received beginning of an audit, and they don't hear anything for a long time. We'll talk about that a little bit later on. That's a real trap, because is it a triggering event? Yes. Could you have turnover between when the event triggers and when you actually have to uphold, agree with the audit, work with the audit? Absolutely. And if you have turnover, one of the things that keeps people like me up at night is you have turnover and the new person comes into the office and they say, oh my God, what are all these boxes sitting here in the corner of paper? We got to get rid of this so we can have more room to put in, new stuff, or put a couch over there, or, thank you for your service. We understand that you're moving to another college. In 30 days, we're going to delete all your email. And the person just says, okay, they got their new job across the country, and the college goes and deletes all their email. But in there are all these emails that have to do with that OCR investigation or that lawsuit or whatever it may be. That's the kind of stuff that keeps me up at night. And then, 30 days go through and it cycles through and the email is like gone. That is bad. So why do we care about these triggering events? The thing that we want to do is to avoid what the courts call spoliation. And spoliation is just a fancy legal term for you've spoiled the evidence. And the problem with spoliation is that if you are accused and found to have spoliated evidence, a court could, not always will, but could make what they call an adverse inference against you, meaning that they will say, you were told to hold on to this certain set of records, you knew you were supposed to hold on to it, you destroyed them anyway, we are going to take it as if everything that was said to be bad in those records actually is true. That's bad because usually you're not as bad as you're being accused of being. And when you've destroyed the records or let them go pursuant to your records retention policy when there was a litigation hold, a court or an administrative agency or an auditor could say, yeah, that was the set of records where they did all the terrible things, and you have no way to defend that, and a court could make the finding against you. So the way that we defeat that is to be conscious of what records we have, what records we're holding on to, and when we get an external trigger, either that there's a trigger that there's going to be a lawsuit, or there's a trigger that we're going to be starting an audit or a program review, and making sure that we hold on to those documents until the time that that lawsuit or that program review or that audit is over. And by the way, you might say to yourself, well, we've provided all those documents to the Office for Civil Rights. We printed them all out. We mailed them to the Office for Civil Rights. They have them, so we can destroy them now because why would they ask for them again? They already have them. And I know many, many cases, and I'm not picking on the Office of Civil Rights, of government agencies across the spectrum who've called back and said, hey, we know from the UPS log that we acknowledged receipt of a box of documents from your campus, but we can't find them. Could you send them again? And then a couple weeks later, they call and they say, you know, we know that we got the second box too, but we've been moving offices or we've been downsizing or upsizing or whatever it may be, and could you send them to us again? And if you've destroyed them, they'll say, oh, well, you've spoliated those documents. And you could say, but we know we sent them to you. And they'll say, yeah, you have to send them to us again, and we'll make an adverse inference against you.
Can I go back?
Yeah.
Can you go back? I was just going to add, what we say policy should allow for administrative access to all institutional records and devices, just to give you an indication of what we're talking about here. How many people in here have smartphones? How many people have smartphones that are provided by their institution? Leave your hand up. How many people have two smartphones, one that's provided by their institution and one personal? How many people have just one smartphone that's a personal smartphone that your institution gives you a stipend to pay for? Okay, those are the people, and that's me. Joe and I work for two different parts of SUNY. My part of SUNY gives me a stipend to buy my phone. Joe has to carry two of them. He has one BlackBerry that work gives him, and then he has an iPhone that's personal. Joe's an easy case because we own that BlackBerry. Right. I'm a much harder case because they don't own it, but I have all kinds of both public and institutional information stored on it, and in my private account, which SUNY doesn't really have access to unless they have a subpoena or my permission. The people that have both are even sometimes a harder one because they're making conscious decisions all the time about what's work and what's not, and sometimes they don't understand the repercussions of those decisions that they're making, and a lot of times those repercussions ultimately come back to bite the institution. We're going to talk more about that in this afternoon, but this is a big emerging scary area for us lawyers to deal with, because basically you're saying all those people that either have personal phones and work phones and make decisions as to how to use each of them, or get a stipend to use their work phone or their personal phone for work purposes, they're end users that are in charge of their own spoliation efforts that will ultimately come back to impact their institution. How many of them actually know that and think about that consciously when they're doing it? Very few of them. And it's a brave new world that we're hitting all the time. I just wanted to jump into that.
You know, and when we talk to our clients, oh, sure. So the important thing is not, this is going back to the Shakespearean, the rose by any other name would smell as sweet. What the government or what the federal courts or state court would care about is the content of the document, not what you call it or where you store it. So if I get notice of a car accident that occurred on campus and someone sends it to my private Gmail account, that is work, even though it's sent to my private Gmail account. And if I use my work account to send out a funny joke to a bunch of people, that is not relevant to the lawsuit usually. Depends what kind of joke, but would not be relevant to the lawsuit even though I'm using my work account. So you can't hide things and put things in one way or another. We highly recommend, and this is how I know I run my own practice, all my personal stuff goes in my personal email. I don't send personal emails from work, and I don't use my personal account for work. Sometimes, occasionally, when someone sends me a work email to my personal account, I forward it to my work account, I delete it from my personal account, and that means to me that if anything were to happen and my boss were to say, I need access to your email account, or we need your BlackBerry, or whatever it is, that's fine. Here's my BlackBerry, here's my email account. All that's on there is work, and it is all of the work. And you don't need to worry about my personal account because I don't use that for work.
Use it for porn.
Oh God. And so that's the way that you balance and properly separate, and that's the way that you keep it yourself safe from those accusations.
The easy answer to your question is if you're a plaintiff or if you are OCR, to stick with our example, again, we're not picking on them, they just happen to be the subject of the hypo. And they come in and say, okay, we need these relevant records, and we go back to them and say, well, we know there are relevant records on this employee's iPad, but we don't have access to that, so we can't get it. Sorry. What do you think they're going to say? They were on a personal iPad? Then never mind. We don't need those anymore. No, they aren't going to say that. The classic example, and sort of the place where this came up first, is in the Valerie Plame investigation of the White House back in the Bush years, where Karl Rove and his people were using their RNC, the Republican National Committee, email accounts to do their politicking, and then their White House email accounts to do their official stuff, and all this Valerie Plame stuff was on their RNC accounts, and the court said, no, sorry,
right.
Those are public. We won't, and they actually forced them to turn them over pursuant to FOIL. So that's where we sort of everyone, that was really smart of them, but it didn't work.
So when you have that trigger and you know that you need to hold on to it, you have a litigation hold, and you have to think about where are you holding this information, because on any of your college campuses you have an unbelievably complicated map of where your data is held. Some of it is held in local servers of just your department, some of it is held in campus servers or university-wide servers, or maybe it's held in the cloud, and maybe they're retained, and maybe they're backed up, and maybe they're not, and maybe it's stored on somebody's hard drive that is not actually backed up. It is very complicated, and you need to know where the records are going to be stored. And you may need to interview and talk to some folks and try and decide where it's going to be.
We need to know that you're using your iPad, for instance. We'd have no way of knowing that unless we went out and talked to you. That's why this can be very labor-intensive, as you can imagine.
And I was having a conversation last night with one of our colleagues who works at a SUNY campus, and she was saying...
Not Geneseo Cell.
Right, not Geneseo. The first thing she was saying is she first talks to the IT folks when they get in one of these litigation holds or they have a triggering event. The first thing she does is talk to the IT folks and have all those accounts locked down. And then she goes and talks to the folks who are actually holding the documents, because you don't want to let the fox implement a litigation hold for the hen house. Sometimes the litigation holds, the people who are being asked to hold on to documents are also the guilty parties, or at least the parties who are being accused of some wrongdoing. And if they have the power to go through and selectively delete emails or selectively delete documents, that is going to be extremely problematic down the line. Very, very problematic down the line. So you want to make sure that if somebody who is the owner of the data is actually being accused of wrongdoing, that you take some steps to separate their ability to delete selective documents or documents that show guilt before notifying them of the event. So You coordinate with the IT department, and that's whether you're in counsel's office or you're in any of the other departments around campus. You should be going back to your institution and coordinating either with in-house or outside counsel if you have that, and coordinating with the IT department to implement whatever holds you have when you have that triggering event. And you would include information that's on various different folks around the campus, because that information is now being held, as we've talked about, by different folks in different departments around the campus. So in a litigation hold, when you have it, so first you have that triggering event, that event that you care about, that you want to invest the time in because you think that it could eventually result in litigation. You reasonably anticipate litigation. You coordinate with the IT department, I would say first, to say, how do we lock down that data and make sure it doesn't disappear? And you document the steps that you've taken. And you should be working, there should be some type of college-wide group that's working to document those steps that you are taking to preserve the evidence. You want to make sure it's maintained. You want to make sure it's maintained in a format that can be accessible and can be accessible in the future. And there are times where somebody is accused of something that's ongoing. And so you don't just have to retain back data, documents or emails or whatever it may be, but there are ongoing emails. They're being accused of ongoing ill work or whatever it may be. And so you want to make sure that you can mirror their email account. And those of you who have homegrown servers, that can be done internally. Those of you who outsource to Gmail or to live.edu, there are options and ways to work on that to mirror the account so you can keep track of what's going on. So let's talk about that continuing quiz that we talked about. The Office of Disability Services, remember we talked earlier, the student who took the quiz, she had an ability to take exams in a different environment. The Office of Disability Services emails the professor at the beginning of each semester, informing them of the accommodations. What about those emails? Are they subject to a hold? Absolutely. Those are emails notified the professor of her or his responsibility. How do you obtain them? Well, I would first start with IT. I would first start with IT and make sure that those emails can be obtained in that way. And then I would talk to the professor and say, this accusation came in. We don't know what the result of it is going to be, but here's what you should do. You may delete all your emails at the end of the semester, whatever it may be. Don't delete these emails.
So just to recap, but with our steps here, we've got the first step where we've been hopefully managing. We haven't talked about that yet. The second step where there's litigation hold trigger event, and that is clearly when you got the OCR complaint and the information request. That's a trigger, no question about it. And now we're at this spot where we're identifying and implementing a preservation notice, a litigation hold. We're identifying what information is relevant, what information is subject to the hold, and we're determining what the best way to go about gathering and capturing that information, making sure it's safe so that we can eventually move on to the next stage where we're producing it to OCR.
Now, how about your accommodation policy? You're in the midst of a review of the policy, and you're just a few days away from putting up the new policy online. Is that old policy subject to a hold? Absolutely. If you consider this triggering event, it's subject to a hold. Does that mean, however, that you can't update your policy? Absolutely not. A litigation hold is not a paralyzer such that you can't make progress on your campus. Put it on a separate site, download it, print it out, whatever it may be, and mark it, document what it is, and go ahead and make those changes. One of the things that courts have said again and again in a lot of tort cases and the like is that you will not be held responsible based solely on changes that you made afterwards. A college can feel free to fix a crack in the sidewalk that somebody tripped over, and it cannot be brought into evidence that 2 days after the person tripped on it, the crack was fixed. So obviously, it was something that was easy to trip over. That can't be admitted into evidence, and there's public policy reasons for that, because courts want us to make those changes. They want us to fix the cracks in the sidewalks. They want us to update policies that are out of date or that are wrong for some reason. And that specifically on its own won't be held against you. However, do you have to maintain the old copies of the policy that you're changing? Absolutely. Would you have to maintain photos of that sidewalk that you fixed? Well, sure, if there's a tort case. And like we said at the beginning, this is just discovery with an E in front of it. Nothing has changed except for the technology where we're storing the documents.
There's 2 points that are raised also by the policy being changed. First off, how do you hold it? You want to, as Joe mentioned earlier, part of the process here is regularly maintaining that litigation hold. If you're changing information, you're not maintaining the hold. Maintaining the hold is holding onto the policy, copying the policy at the time that it was in place, at the time OCR is looking at. How would you ever know about that? I probably do a final review on these things, but I wouldn't know if the college has a committee often working on revising this. I only get it afterwards on many of my campuses. The IT department sure not going to know about it until they get the request to change it on the website. How do you know about that? You have to go out into the real world and talk to people and determine during that relevancy process, determine, okay, what's relevant now and how do I make sure that that stays that way? Do I need to do a screenshot of it? Do I just want to hit print on it? How do I want to do it? But the bottom line is you wouldn't know that unless you were actually going out there talking to people and taking this seriously rather than just slapping a hold in place on whatever email backup tape you have or whatever the case may be. Okay. So, again, now we're in that dichotomy that we set up earlier. If we're looking back at some of the early slides and where we are with the hypo too, we're now to the point where we're reviewing evidence. Now, the one we set up is probably pretty easy, frankly, but we're going to make it difficult in a little bit. But oftentimes, this is the most difficult, the most expensive, the most time-consuming part of the whole process. This is why putting the hold in place can be fairly easy. All right, we all have advanced, really good IT people on our campuses that can hold hundreds of terabytes of data, no problem. They could just copy everything that you do all day, every day, and put it on a server somewhere, in India, and it would be fairly cheap to do, actually. And again, we can our ability to hold in that type of information is greatly outpacing our ability to manage that information. Now's the point where we're managing the information. This is why we wanted to have that hold be reflective of the seriousness of the case, and we don't just put on a hold all the time that says we're just going to keep everything all the time forever. Because at some point, we're going to have to go through everything that we've been keeping forever and determine what we're actually going to turn over. We're going to have to review it. Often, we'll have, in the federal context, we have what's called a meet and confer conference where we actually sit down. We've already put the hold in place. We have the information. The hard drive is in my file cabinet, locked away. The emails are on a tape that IT has, or a removable hard drive that IT has made for me. And now I'm going to sit down with the attorneys for the plaintiff, and we're going to talk about what the discovery process, what's in play, what's out of play, those kinds of things. So there'll be negotiated parameters. Sometimes we even go down with search terms, and we'll come up with search terms that we're going to apply to that information and give over everything that's not privileged that comes up when we do that kind of search. It's very labor intensive. Often big law firms have whole teams of low-level associates in basements in Lower Manhattan doing nothing but going through this stuff. They make a lot more than all of us do, but they have really, really awful, boring jobs. I'm sure Joe knows a few of them too. But it's very labor intensive, and the fact that they make a lot more means you're paying them a lot more too, so it's very expensive. Nowadays, we're getting to a point where there are many tools available. There's something called computer-assisted review. We're going to talk a little bit more about that this afternoon. I think it's very important. All I really want you to know for this session, for the basic level, is that there's such a thing, and we are moving from a place where we are doing linear review, where we've got those teams of attorneys in basements doing things, to where we're doing this with software a lot more nowadays. That being said, the software is now just very expensive. So it's a little bit less labor intensive, but equally as pricey. Reviewing cost shifting is a major concern. Again, I mentioned earlier that 90% of the time they're the ones asking for it and putting the demands on you, them being OCR, them being the plaintiff, them being the Department of Education that's doing an audit of your program. They're putting the burdens on you, you're picking up the tab. Okay, they're ordering surf and turf, and you're paying for it. So outside experts are often common. I'm going to talk to you again this afternoon about how to go about acquiring outside experts. The aim should be to achieve proportionality. Again, when we're dealing with the other side, we're trying to say, no, that's unreasonable for us to apply this many search terms to this gigantic quantity of data. We're only going to apply the last names of the major players. We're not going to apply their first, last names plus Pat and Patricia and those kinds of things. Ultimately, you have to know what you produce. You have to, at some point, somebody has to read over everything. We don't want to get into a point where we're doing mass document dumps on the other side without first having reviewed it ourselves, and we don't know what's in there. We don't know that there's privileged information in there, and we don't know that there's highly damaging information that would be much more advantageous for us to settle the case early rather than keep going. So know what you're producing. You got to document the process. You're going to see this as a theme throughout here. Document what you're doing. You're going to all this trouble. The bottom line is the law requires you to be reasonable when you're going to all this trouble. But if you just go into court later on and say, oh, but it was only reasonable for us to do this at the time, and you're just making it up as you go, or it appears, even if you're not just making it up as you go, it appears that's what you're doing if you haven't documented what you're doing. Okay, privilege logs is a big part of that. Obviously, we withhold privilege information, but we have to document that and tell the court that that's what we're doing so that someday it can review whether or not privilege was properly applied to that information. Finally, be strategic. Think about what you're producing. Think about how you're producing it. The other sides are very, especially in litigation, especially in some parts of the country, and I can say this because we're in New York, we have many campuses, especially in Long Island, especially in Los Angeles, okay? The plaintiff's lawyers are very strategic about how they bind you up in this process so that you aren't defending the case. So you have to be strategic when you're going about it, you have to be thinking about it, and you have to be strategic ahead of time in how you manage your information and make sure that you are prepared for the inevitable expensive lawsuit that's going to be subject, or that information is going to be relevant to and potentially evidence in. All right, moving on to with our hypo here. Neither the professor nor the Office for Disability Services saved the accommodation emails. But IT thinks that they're on backup tapes along with millions of other emails. Okay, I told you we're going to make it a little bit harder than it has to be. What made it harder is that the professor and the Office for Disability Services didn't save it. Why? I guarantee you if you go in there, they'll point to each other and say, oh, but the professor is supposed to retain those. Oh, but the Office for Disability Services is supposed to retain those emails, not me. I don't have enough, my 10 gigabytes of storage that I'm given by IT isn't enough to hold all those emails, right? The limited searching technology available, so we've found them on the backup tapes, but now instead of having one email or two emails going back and forth describing what accommodations are available, and this is relevant ultimately because the accommodation said test, and this is a quiz. So did it apply or not? That's going to be the ultimate focus of OCR, I imagine, going forward. So we need to find those emails, see what they really said, what the professor was really told to do. Whose fault is it really? How do you apply the policy to the accommodation that was given? We've got 4,000 emails now. Who searches those? Not OCR, somebody in your office, okay? That's why, again, the burden is on you. If you didn't manage them properly by saving them, and that could not be, and it's very possible that that's not their fault, that ultimately there wasn't a retention schedule in place that said you're supposed to save those for a certain amount of time, or there was a retention schedule, but again, they're pointing fingers at each other because nobody was made responsible for those records. Nobody was trained on how to retain them. Nobody was given the responsibility for retaining them. And until now, nobody's had any consequences for not retaining them. So these are why we have to have policies in place. We have to have responsible, appointed individuals that are in charge of everything that's a record. We're going to talk more about what a record is a little bit later. But having custodians is important, or they're just going to point to each other. What if you don't find them at all? Joe talked to you about adverse inference instruction. OCR is not going to be happy. You're going to get a nasty letter, maybe a fine. Okay? So it comes down to that. Did I skip something? No. Okay. So production. I'm just going to talk briefly about this so we can keep moving along to records. But generally, we're just going to produce active records. So a lot of times you don't want to just print stuff. A lot of people just think, oh, I'll print it to save it forever. I don't worry about it. No, a lot of times you need the actual active record the native format of whatever kind of, if it's a Word document, if it's a PDF, if it's an Outlook or a Gmail document, they want to see the metadata that's attached to that. They want to see the active document, not just a print off. Again, document what you're doing. This is what we gave you. As Joe said before, we have that invoice that says we sent this box of documents to you, OCR, and even if you changed investigators and the old one took it with them or burned it on their way out the door, you should have saved it. And then at least we can have that conversation, and they can't just say, oh, well, you never sent this to us, when we know we did. We've got to document that kind of stuff. Ultimately, if there is inadvertent, I don't want to get too much into this because you don't want to rely on clawback, but there is a procedure in the federal rules that if you give privileged information, because the universe of data we're dealing with is so large, there's inevitably, nothing's perfect, there's inevitably going to be mistakes made, that you can request that back. And as an attorney, if I get that information, I've got a duty to give it back to the other side and not use it during the course of litigation. That being said, again, you can't unread it. All right, you can't unread that inflammatory email, and you can still use it for cross-examination, those kinds of things. So you don't want to be turning stuff over. And you want to, again, make sure you know what you're producing. Be strategic about it. Finally, you want to explain what you're doing. And this is one of the places that without IT, without the lawyers involved, we need you involved. We need you to be able to tell us. We need you, if you're giving us, or if we're going in and taking a whole ream of your emails, we're going to have to eventually have to sit down for a couple hours maybe and go through that and have you help us explain. You know, we'll have to sit down with the professor in the other example and say, okay, when you read this email from the Office for Disability Services and it told you that you were supposed to provide accommodations, allow the student to take tests in another place, what did that mean to you? Well, she's going to say, well, I thought it only applied to exams and this was just a quiz. So we need to know that so that we can explain ourselves and know that's not completely unreasonable, right? At least we have some excuse if we didn't perfectly follow the regulations the way OCR does. We need to know that kind of stuff. We need to be able to explain what it is that we're producing. Again, this goes back to being strategic. The first step a lot of the time is making sure counsel understands. Because if you understand and your boss understands and IT understands and Joe and I don't understand, it doesn't do any good because we're the ones that are out front having to actually make the arguments. Yes, please.
You talked earlier about those 4,000 emails.
Yeah.
Let's say out of those 4,000 emails, there are 50 emails that are relevant to whatever the case is. You say that we have the responsibility to go through those, but who has the responsibility to go through those? Because somehow that process is going to have to get documented as to whoever culled through those 4,000 to determine that these 47 are in fact the relevant ones. Should we be looking for our counsel to do that, or who does that?
That is an institutional decision that you'll have to work with your counsel on. I will tell you there are many cases where I have 6 campuses. I can't do that for every case like this. So a lot of times I will be relying on people to narrow it down to that 50, and then I'll go through the 50 and determine what's relevant. Now that's an institutional decision because of the way we're structured. However, there may be other cases where it's too important. There's too much at stake here. There's an entire department's budget at stake, and I'm going to sit down and do it, or we're going to farm it out with the AG and determine who does it. But that's an institutional.
The documentation be to say the appropriate VP determines, because obviously again you don't want the Fox deciding what 47 emails are relevant.
And honestly, in the context of in the OCR complaint, they asked us what's relevant. So they're expecting us to make some kind of initial determination. They're expecting we're going to do that in good faith. And if there's some evidence that we didn't, we're going to be in really big trouble, right? They control Title IV funds. So that's that case. In the litigation context, again, be strategic. You might go through all 4,000 of those emails and say, yeah, there are 50 relevant ones. Here's 4,000 emails. Now you do it. We did it. Why are we doing your work for you, right? So again, be strategic. They're being strategic. There are times you will make document dumps, but my point is make sure you know what's in them first.
Yeah, I mean, it's the cost-benefit analysis that we talked about earlier for whether or not something even triggers. Yeah, I mean, if you have a campus that has outside counsel and you're paying X number of hundreds of dollars an hour, your institutional bean counters may decide we have to figure out a way to do this in-house. It would be more expensive than settling it just to have, because sometimes it's $4,000, sometimes it's $40,000. Seth was mentioning earlier people who graduated law school when we did, who went and worked and do document review for big firms, and sometimes they'll spend a year or two looking through somebody's email on a case, just day after day after day reading email at however many hundreds of dollars an hour they'll be billing out for. Now, that may be okay if you're a major Fortune 500 corporation, not so okay if you're a college or university. So it really is cost-benefit analysis.
That makes sense. But a lot of times also it's going to come down to your institutional structure. Certainly counsel will have to have the ultimate decision, make the ultimate call as to who is the appropriate person in this particular case to be doing this. That's going to be done with the bean counters input. It's going to be done with the managerial input as well. But ultimately, it's going to be an institutional. It's going to be a case-by-case analysis, as we talked about earlier. How do you implement a litigation hold? You do it on a case-by-case. You custom fit it to the circumstances, and you're aiming to achieve proportionality. You don't want to spend $80,000 in outside counsel fees to go through a case that the worst thing that happens is you get a nasty letter from OCR, right? But if it's federal litigation, you probably do want to spend it because it's going to cost you a lot more than that if you lose. Okay, we'll take a break here real quick, just 5 minutes. I know that was a lot, and that question broke it up a little bit, but let's just breathe. I was sitting here the other day in one. I won't mention which one. I won't even mention which room, and I was just thinking, I just wish I had a minute to stretch a little bit. To check your email, you don't have time to respond. Just make sure nothing's on fire. As long as nothing's on fire, then we're just going to keep going. You can respond after the session. But I know you're all drifting and starting to do it anyway, so I figure I might as well give you 30 seconds to do it. Now, finally, please pay attention. 9 out of 10 judges say this stuff is important. Ready? All right, records management. Again, we're going to talk a little bit more about this later. Something's on fire, apparently, at one institution, but I'm just teasing. We're going to talk about records management. We call it records management. That's just the choice. We've been doing this presentation for a while. We always called it records management. You'll hear it called a lot of different things. We use the acronym RM because we love acronyms at SUNY. Left of e-discovery, sometimes you hear it called. Again, it's left of e-discovery because this is what comes first. This is what prepares you for the e-discovery. Information governance, information security is a big component of it. I wouldn't say they're the same thing. And records retention. When people are talking about records retention, they're just talking about a small component of records management. What records are we talking about? Not going to talk about these records today, okay? Unfortunately, if you want to talk about them at lunch, we can talk about the good records. But not today. We're going to talk about these records, records that fit this description. First two are really easy. We're not going to spend a lot of time talking about the first two. But basically, that's everything, all right? All documentary material, everything. Unless it's in your head, then it counts on this number one. Post-it notes, whatever it may be. Two, that is received, stored, produced, transmitted by any department, office, employee, or agent of the course of business. That includes stuff on your iPad there, as long as it's done in the course of business. That includes pretty much everything, whether it be my personal phone that I get a stipend for, or Joe's BlackBerry that belongs to the institution, or if it's on a server, or if it's even just bleeps across the server because it was sent and received from a faculty member real quick while they were on campus. Okay, that's going to be received, stored, produced, or transmitted within the course of business. So those two, again, that's everything. Unless it's just in your head, it's going to qualify for the first two. This last one is the important one. It has a legal, operational, or historical value to the institution. We're going to talk about more what that means in a second, and a lot more this afternoon because that's a really important. Defining what is a record and what is not a record is the most important part to controlling records. Why? Because there's a difference between records and ESI. ESI is everything else. That is 99.9% of the data that's stored on your on your IT department servers, on your phones, on your iPad, everywhere in the file cabinets that you have. Actually, that wouldn't be ESI, it'd just be information, but you get my point, right? Everything is ESI. Everything that is controlled with little zeros and ones all across everywhere is ESI. There's tons of it. Very little of it has legal, operational, or historical value to the institution. That stuff of it is a record. Why are we keeping the rest of it? Sometimes you need it. Most of the time you don't. Most of the time what we're keeping is stuff that is not a record. It's just electronically stored information, and we're storing it only because somehow it got caught up with all those records that we actually do want to be keeping. Okay? My goal today, one of my main goals, is to try to get you to think more strategically about how you keep that information and what you keep, and to keep your records and keep them safe. And you know what? That makes those records a lot more valuable, because it makes them more useful. It makes you prepared for e-discovery. It helps you in all kinds of ways. If you get rid of all that clutter, it's cleaning up your desk. That's all we're talking about doing here. But you can't do it unless you understand your systems to some extent. Now, here's an important concept. Anticipation of litigation can convert relevant ESI into a record. So you've kept this information, you've kept this ESI, you didn't have to, but you kept it anyway. Now, boom, all of a sudden it's relevant to litigation. Now you have to keep it. Now it becomes a record. Now it becomes a burden on you, and it didn't ever have to be, because you didn't have to have it around in the first place. We're going to talk about why I call it a burden later on this afternoon, but trust me, it is. Most of the time. Even though we're all just and righteous in all that we do all the time. So what is a records management policy? What are we talking about? We're talking about something that classifies records, determines what's a record and what's not a record. It tells you that point 3, all right? So you don't have to go thinking about that about every email. This is going to tell you a good records management policy will. It controls the lifespan. That's the records retention part of it. It tells you when you can get rid of what and what you have to keep for what amount of time. It controls access. That's an information security element. This is not an information security presentation, so I'm not going to go into it deeply. I'll touch on it briefly this afternoon, but it's an important component, and it's definitely an important part of records management policy, and I don't want to go through the whole thing without mentioning it at all. It assigns responsibility. Again, we talked about this earlier when we talked about how the Office for Disability Services and the professor both thought the other one was supposed to save the email. Neither one of them did. Why? Because neither one of them was made responsible for it, presumably. If they were, then it's an easy case, and that person just didn't do their job. But chances are it was because they both thought it was the other one's responsibility, and it was not defined anywhere whose responsibility it actually was. Finally, it plans for litigation. It talks about the litigation whole process. It talks about who's involved in that. It makes sure that people get together and think about these things, and again, act strategically and think about them ahead of time. Who's going to hold the information? Who are we going to talk to in order to find the information? Those kinds of things. So, records retention, just a brief little bit about this. We talked about it earlier when we were talking about that hypo, how probably somewhere it said that email was supposed to be kept, but it didn't assign responsibility. The retention part of it would have told you how long it's supposed to be kept. It delegates power to destroy records. At SUNY, everything, once it's determined that it's a record, it's a state record. The only way we can destroy a state record is by having authority. Where does the authority come from? Only 2 places, statute and state archives regulation. The state records retention schedule is an approved regulation of the state archives. So unless we have that schedule that says we can destroy a record, nobody, not a single SUNY employee, and I guarantee you a lot of your institutions, especially state institutions, are like this. Privates should treat everything like it is. Nobody is authorized to destroy a record unless the records retention schedule gives them permission to. Most people think that, I want you to sort of flip your thinking about records retention schedules. It doesn't tell you how long that you have to keep something. It tells you when you can get rid of it. Okay? That's how you ought to, because if it doesn't tell you when you can get rid of it, then it's no good for us. And that's what we're really trying to get to. We're trying to get to that 3 years, that 6 years, wherever, so we can get rid of this burdenful record that we have laying around and making our lives difficult. Thank you. Finally, it reduces the universe of potentially discoverable information, is the way I look at it, by allowing for predictable discovery or destruction of records. So we're constantly, why are we trying to get rid of it? Because we're trying to reduce that universe of information that we have to pay attention to. It allows our policies to be much more effective on that universe of information that we actually have to keep by getting rid of all the stuff that we didn't have to keep. What's a record retention schedule look like? You all know. It looks like this, right? Because you all memorize the ones that apply to your departments, I'm sure. I hope that you do. They all look pretty much like this. It gives a name for it. It tells you what it looks like. It tells you the minimum retention period, and it tells you why. If the good ones tell you why, because we don't just want to throw things at you. We want to tell you why. This right here is the statute of limitations for contracts. So those would be potentially relevant to contract actions. That's why I keep them for 6 years. That's statute of limitation on contracts. That's pretty much what a schedule will look like most of the time. Finally, it assigns responsibility. We already talked about this, why that's important. But really, unless you have people who are responsible and people will be held accountable, we're all pulled in too many different directions. All you have to do is look at the schedule to this conference, and you'll see all the different directions that everybody here is pulled in. Everybody on your campus is the same way. And if leadership is not holding people responsible to these tasks, to completing these tasks, then they're going to complete the other ones that the leadership is holding them responsible for. So it's important to assign responsibility and enforce it. Our audit teams are now auditing for records retention compliance, and so should yours be. It's important stuff. There's a huge burden to the institution if you're not managing it properly. Integrate with IT resources. This is one that the IT guys love. When I say guys, but 99% of them are. Well, when we go talk to them, we tell them this. We tell them, you know what? Why are you you know how you get those things in your email that say, oh, you're about to go over your size limit? Every time they send one of those out, I tell them, when the person writes you back and says, no, I need more space, you should go back to them and say, why? Show me where in the records retention schedule it says you have to hold so many records in your email system that you should have more than 1 gigabyte of data. Okay? And 99% of them couldn't tell you that. What do they need to do? They need to go clean out their boxes. They don't need more space.
You don't really deal with faculty very much.
As little as we can.
Because we've just gone through I'm the IT guy that you keep referencing. So we just gone through an email migration, part of from an old system to a new system. So part of what we made was for our standard criteria was a good record management system, an archiving system.
Good.
And when we go to the faculty and talk to them about archive periods, they will have nothing less than 5 years, and a lot of them are 15 or 20 years in the course of their career because of the research data that they store, and they don't want to store it. They have hundreds of thousands.
Okay, if it's research data, and they can, again, integrate it with IT. All they have to do is, I'm not saying don't give it to them if they need it, but if they don't need it, then don't give it to them. I guarantee if you go into those, you will find a lot of stuff that is not research data, that is just, back and forth nonsense between them and a colleague about where they're going to meet for lunch. Okay? And the problem is when you get that patent suit and they're trying to go back and say, no, I discovered this 5 years ago. Here's the email I sent to my colleague. You got to go through, you got to find that email, and you got to find it in the haystack of all the other emails talking about where they're going to meet that colleague for lunch the day before, the day after, and happy birthday to their grandkid. Okay?
But you can
That's why we got to shape it down so that then we can go, boom, here's the email that proves that I invented this new drug 5 years ago. And now it's relevant to the patent suit, and now you have it. I got to tell you, if you have all those other ones in there, sometimes you may not even be able to find it. Okay, again, as I said before, our ability to create and store information is greatly outpacing our ability to manage it properly, and that's why we need to use our brains to do it.
What you can do with faculty is not let the perfect be the enemy of the good. So if they want to hold on to their research things forever, essentially, well, can you at least get them to do with their class work? So you have a retention schedule for grade complaints, and let's say students in your policy have a year to complain about grades, or a semester, or 2 years, or whatever it is, and have them put all of those classes in one folder. You have a spring 2013, and in that you have your 3 folders of the different classes that you're teaching, and put all the correspondence for that class in that folder that's a subfolder of spring 2013, and then when that records retention policy is over for that grade complaint, delete that whole folder. At least you're making some progress, and you don't want to let the perfect be the enemy of the good.
And why can you delete it? This is from the federal rules, as I say, sort of set the benchmark for everything else, but the standard applies everywhere. Absent exceptional circumstances. If you delete something pursuant to a bona fide records retention program, and then later you come back and don't have it, whether it's relevant to litigation, the patent suit, whatever it may be, you won't be responsible for having deleted it as long as you did that responsibly pursuant to a bona fide records retention schedule. That is a really important point, because basically what we're saying is, again, it gives you permission. The records retention schedules, the records management policy gives you permission to get rid of this stuff. And once you do, it's okay. And I know we'll all get into but what if it proves our innocence? Okay, we'll talk about that this afternoon. Please come back. We'll go into a little bit more detail about that. But let me just suffice to say, it usually doesn't. Even though we're all just and righteous, a lot of times our emails don't show that to be the case.
Litigation comes in and have identified that individual and they're requesting email communication between that individual and the student, for example.
Sure.
And IT says they're gone, there's no access to that.
No, that should be the answer, right? You don't delete an email account permanently the second somebody leaves. You would have to look at their job functions, see what they would have. What, you don't have it? I mean, this isn't gonna help you if that's the answer, because it's not that what you have to do is remind yourself it's not that employee's email account, it's our email account, it's the institution's email account. So why are you deleting? The institution's still here. The employee might be gone, but the institution's still here, and so they're just as relevant as they were before that person left. Now, the ones about launch aren't, but the ones about the patents are. Right? Or the OCR complaint, whatever it may be, those are still relevant.
It's content of the record, not where we store it. My personal email, my work email, your email, it's the content of the record that's important.
Yeah. So this is an important point, and this goes back to what I said earlier about how ESI can be converted to a record by becoming relevant to a potential litigation. So even if your retention schedule says you can get rid of it after 6 months, if you've got a litigation hold on it, you can't, and you lose the protection of the safe harbor. All right, so real quick, we'll just put some of this into practice. So the emails from the Office of Disability were supposed to be retained as records related to determination and provision of accommodations for 3 years. Why weren't they saved? Nobody was appointed. We already talked about that. What if they weren't on the retention schedule? Well, then it's nobody's fault except your own. It's institution responsibility, and the institution's going to pay the price for it. With a nasty letter from OCR, maybe a sanction, maybe worse. Okay. What if the retention period was 6 months, which is actually might be reasonable in this case because that gives the semester, right? That gives you through the semester. You get the email at the beginning of every semester. That gives you through the semester, and then you got a new set coming in next time. But the OCR request didn't come in for 8 months. That's your safe harbor, okay? The professor held it until 6 months and 1 day, and then she deleted it. And now OCR comes and says, we want to find that email, and we say, sorry, you know what? We can give you next semester's one, but we can't give you last semester's. We got rid of it, and you know what? That was reasonable to do so because the semester was over. We hadn't heard anything. The student already got her grade, and we were just moving on with life because we didn't know that later on they were going to complain to you about it, okay? And if you wanted us to keep it longer, OCR, you should have had, and I hope there's nobody from OCR, you should have had a regulation saying that because you do have a lot of regulations that tell us how long we have to keep things, and those will be integrated into our records retention. Clery stuff, got to keep that for 7 years a lot of the time. If they come in and say we're doing a Clery audit and we want to go back 8 years, and we say we only have 7 years of stuff, they can't do anything about it. They have a regulation that says we're supposed to keep it 7 years. That's what we did. Okay? And that would be the same response I would have in this case. Yeah?
Do you have to look first?
Yes, you have to look first, especially if you're not following your policy, and that's a very important point. Okay, that's a great point. We're going to talk about that a little bit more. We'll finish this one up next semester. Hopefully, you guys will come back. It'll be a little bit more fun because we won't be being taped, so we can say all the nasty things that we didn't want to say now about our other colleagues that aren't here, including you if you leave. All right.
Thank you very much.